Okay, ladies and gentlemen, I think we are ready to reconvene the adjudicatory hearing on the Raynham Park LLC application. And if there is no other comment, I will pass the ball to counsel for Raynham.
Chairman, the next witness is Mr. Bob Green, and Stephen Schreier from Blank Room will be handling the examination.
Good afternoon, Mr. Chairman.
Mr. Schreier is one of the lawyers about which Mr. Mnookin was speaking.
One of the many lawyers that is privileged to be a part of this whole proceeding, and thank you all for having me. Before we begin, I'd just like to advise the board that Mr. Green had a bout with throat cancer about 7 years ago, which he was successful in defeating, but that does impact his ability to speak a little bit. So he will certainly speak as slowly as he can, but if you have any questions about that or you want to let him know that you can't understand something, certainly let us know.
Great, thank you for the heads up on that, and we'll just be very straightforward if there's any issue.
Yes.
Thank you.
Mr. Green, can you describe where you were born and tell us a little bit about your background?
Yes, good afternoon, Mr. Chairman, Commissioners. Thank you for giving me the privilege to address you. Councillor, I was born in Hertford, just outside London, but essentially that was in 1941, and I lived in London from that point of time until about 1989, when I moved permanently to the US, apart from obviously a few months when we were evacuated during the war. So other than that time, I lived permanently in London.
Can you describe, prior to coming to the U.S. in 1989, can you describe your employment background?
Yes, I left school after high school and went to work first at a bank in the City of London. It sounds rather archaic now, because it was known as the Bank of British West Africa when there was still British West Africa. But I worked there, and then in around 1960 and 61, the UK Parliament passed the Betting, Gaming and Lotteries Act, which legalised off-track wagering, and I went into business, or I started to work in that business, and worked in probably one of the first retail betting outlets in London in 1961. During that, I became a director of a small family business, and built that business up to about 70 retail outlets. That business was then acquired by a company called Mecca, that was a public company, and over a period of time I developed that business, and I was the Chief Executive Officer and Chairman of that business, until it became the third largest operator in the UK. After that, we were then part of Grand Metropolitan, which was a major conglomerate, international conglomerate, and as part of that, I bought the number 2 operator in the UK, which merging the 3 operator Mecca with the number 2 operator which was William Hill, we sort of leapfrogged as becoming the leading UK operator and probably the leading wagering operator worldwide. Also during that period, Grand Metropolitan owned London Clubs, which was the largest casino operator in the UK and Europe, and I was the joint chairman of that company, as well as the chairman of the new William Hill. So that really takes us up to 1989.
Okay. As I understand it, William Hill, you said, was the largest operator in the UK. I think it had some 2,000 betting outlets at the time, and that organization had betting and wagering facilities in many countries. Is that right?
Mainly, it was principally in Great Britain, Ireland, and certainly some in Belgium. Those were the main areas.
Were you required to be licensed in your capacity with William Hill for each of those countries?
Yeah, for each division, one had to be licensed by the local, what was known as a petty sessional division, but there were hundreds of those in which I had to be licensed.
Can you briefly describe the circumstances of what brought you here to the United States in 1989?
After the takeover of William Hill, because of the size of that transaction, it went probably to the equivalent of your antitrust mechanism, which was known as the Mergers and Monopolies Commission, that operated under the Board of Trade for approval. And the Commission approved the takeover, but informed me as the chairman that we should no longer, we should not grow anymore. We should not get any bigger in the UK, and that only organically, but by the size of the company in that market, we were number one, and were told that, you know, that's it. So from a business strategic point of view, I had to look outside the UK for expansion. And essentially I concentrated on the US and the Far East, and began due diligence in those areas to see where I thought we may expand in the future. Part of that look and due diligence in the United States at that time were looking at the states that had either introduced or were about to introduce off-track wagering, and there were, you know, only 3 or 4: Illinois, Connecticut, Pennsylvania, and I looked at those opportunities and felt that the Pennsylvania and the location of Philadelphia Park represented, you know, a very good initial move into the US for William Hill and Grand Met.
Okay. I think we've heard a little bit in the proceedings about how it came about that the track was purchased in 1989 and how others, Mr. Manukian, for example, were involved in that transaction. I think probably as part of the suitability report, I'd like to just ask you that at one point in time, there was a licensing process in New Jersey that involved some of the track ownerships that you were involved with. And at that hearing before the Casino Control Commission, there were questions that arose about a relationship that you had with an individual by the name of Robert Brennan in the mid-1990s. And that was part of what the director had mentioned during her review of the suitability report earlier today. So I think for purposes of our addressing the issues that were contained in the report today, I'd ask you to identify Mr. Brennan, if you could, and tell the commission, if you would, how it came about that you came to know him.
When I first looked at the opportunity I felt was there at Philadelphia Park, and bear in mind we were still part of William Hill and Grand Metropolitan at that time, I arranged, or my people in London arranged, that I would meet the chairman, who I didn't know who it was, the chairman of International Thoroughbred Breeders, which was a publicly quoted company. And accordingly, I went there to Philadelphia Park and met the chairman, who was Mr. Bob Brennan. And we spoke about a potential deal. I went back to Grand Metropolitan. We spoke about it. Our obviously, because of the size and reputation of Grand Metropolitan, we did a background check on ITB, which is to give them an acronym, and Bob Brennan. As a result of that, it was discussed. We knew that we were dealing with a very flamboyant, controversial individual who was the chairman of that company, but there was nothing to suggest that we should not enter into negotiations with him, nor should we anything to prevent us doing a transaction with ITB. Conglomerates being what they are, that transaction never came to pass because another element of Grand Metropolitan, the food and drink division, was looking at the opportunity to acquire Pillsbury. And obviously we spoke about this in London, and the view at Grand Metropolitan at that time was that if Grand Met is going to pursue Pillsbury, which was a very mom and pop brand company with Doughboy, Green Giant, Burger King at that time, it may not be quite right timing for us to pursue a racetrack and off-track wagering opportunity in a place like Philadelphia. No reason not to, but the whole thought was that knowing that the Pillsbury takeover was going to be a hostile takeover, as it was successful, but that we should, leave the racetrack, off-track side of that for another year or so, or a couple of years. I, said I didn't really want to kick my heels for a couple of years, and that with their consent and their blessing, I would leave the chairmanship of William Hill and Grand Metropolitan and see if I could pursue this opportunity myself as an individual, which I did, and left Grand Metropolitan on very amicable terms. In fact, I continued to stay on a number of their boards, and went back to ITB and said, look, we're not doing the transaction as Grand Metropolitan, but I would like to do exactly the same transaction as was contemplated by Graham Met to do it myself, and over a period of probably a year or so, I negotiated directly with Bob Brennan, who was the chairman of ITB, and finally consummated a transaction. It took a while to put the equity and the financing together, but in 1990 we completed the acquisition of Philadelphia Park, by which time I had known Bob Brennan for over a year, and obviously it started off as purely a business relationship, but I got to know him socially over that period of time. Knowing, obviously it was well known that he was, as I said, very wealthy, flamboyant, outsized personality type of individual.
Okay. So you acquired the track and I assume continued to operate the track and were licensed by the authorities regarding racing in Pennsylvania at that time?
Yes, we were, and the various other divisions that were necessary to be licensed. Yes, sir.
Okay. At some point in time, after you acquired the track and had met Mr. Brennan and became socially acquainted with him, did you become aware of proceedings by the Securities and Exchange Commission regarding Mr. Brennan and his company, First Jersey Securities?
Well, we knew about that going back to prior to the acquisition, because there had been filings and various issues that had been brought by the SEC going back to the early 1980s. So from our perspective, it was a continuation of matters that had occurred over the last 10 or 12 years, of which nothing had come of them. They had either been cleared or not pursued, so it was nothing, if you like, out of the ordinary.
Mm-hmm. Did there come a time when you became aware that he was actually convicted of a securities violation in 1994?
Yes, I think it was late 94 or nearly 95, somewhere in that arena, which was a civil case that dated back about 10 years earlier.
Were you or any of the companies that you were associated with ever involved in any way with any of the alleged activities that resulted in those charges or that conviction?
No, sir. No.
Did you ever engage in any personal business dealings with Mr. Brennan?
Yes, there were over a period, there may have been one or two, but there were certainly, I had dealings with a trust that he had set up for his 3 children, and there were a number of transactions that I did with the trust for probably a period of 15, 18 months.
Okay. And during that period of time, were you aware that Mr. Brennan had been convicted of the offense that we talked about earlier?
Yes. I spoke with him about that. His position was that it was similar to similar civil matters that had been brought against him, that he'd always been successful in defending, and that he had made an appeal against that particular filing, and that he was confident that he would be exonerated on appeal. He was very convincing about that. In fact, I asked to see the brief of that appeal that was prepared by probably one of the leading jurists at the time, Judge Higginbotham. I read it, and from my perspective, I thought that there was every likelihood that that appeal would be successful.
So you indicated that the business dealings that you were talking about with him personally, they weren't actually with him, they were with an organization or an entity that he was a part of, is that right?
Yeah, he was a 25% owner of the trust. The 75% were owned by his 3 children, grown-up children.
Did there come a time when your business dealings with him ended?
Yes, the investment vehicle that I had personally that had some business dealings with the trust, that after his appeal was unsuccessful, I immediately informed him that in that light that there should be no further transactions, and there were no further transactions that took place between me and or the trust.
In that period of time when you were doing business, to your knowledge, were any of the business transactions that you engaged in with the trust or related to any other entities of Mr. Brennan during that period of time improper or illegal to your knowledge?
None whatsoever, no.
We talked briefly at the beginning of your testimony about the fact that you had a hearing before the New Jersey Casino Control Commission and an investigation that was done by the New Jersey Division of Gaming Enforcement. Were all the activities that you just described that you engaged in with Mr. Brennan a subject of the hearing that was held before the Casino Control Commission?
Yes, a full hearing.
And to your knowledge, were all of the business and personal relationships that you had with Mr. Brennan explored in detail at that hearing?
Yes, very much so.
Can you tell the commissioners what the outcome of that hearing was?
The outcome of the hearing was that I was found suitable and qualified, and that there were 2 requirements of me. One was that I would keep the commission updated about the bankruptcy proceedings involving Mr. Brennan, of which there were hundreds of named people in those proceedings, and I was one of them, and that I would keep the commission updated on that proceeding, and 2, that I would have no further business dealings with Mr. Brennan.
Just for purposes of the record, I believe as an attachment to the Raynham Park Suitability Report, you'll find Exhibit 17, which is the order and determination by Chairman Hurley of the Casino Control Commission. So these conditions were imposed upon you. Did you follow both of those conditions, Mr. Green?
Yes, sir.
Okay. You mentioned that one of the conditions required that you report on a regular basis to the New Jersey regulatory authorities at the New Jersey Division of Gaming Enforcement and the Casino Control Commission regarding the proceedings in a bankruptcy involving Mr. Brennan, where you were named as a defendant along with, I think, 23 others, correct?
Yes, sir.
Can you describe that bankruptcy proceeding and what the proceedings were about and what happened in that bankruptcy?
Yeah, the trustee who was appointed to deal with this matter filed a complaint, and certain restrictions, I think that is the word,
Restraints.
restraints, which we challenged and took to court, and they were removed. There was no further action by the trustee until about a year later, when another complaint was filed, which we challenged and defended in court, and were successful, and I think we in fact got summary judgment against the trustee. The trustee then appealed that decision, and then the trustee then asked for reconsideration of that decision. At the reconsideration, again, I was successful in that case. Following that, the trustee then appealed the reconsideration, and we had, if you like, I had won every case involving the trustee, but the legal bills, in terms of continuing to have to defend what I considered a frivolous action, was just, the trustee had unlimited funds by disposing of various assets that Mr. Brennan owned, had unlimited funds to continue this legal process. And at the end, I agreed that we would settle the matter. I think it was for a settlement of $200,000, because that was a lot less expensive to me than going through another bout of legal proceedings. So after being successful 3 times and having to spend a significant amount in legal fees, I felt it was just much more economical to get the thing out of the way and settle it, which I did.
Commissioners, just for the record, Rainham Exhibit 10, which I believe you have in your packet, is one order from the bankruptcy proceeding whereby Mr. Green was granted summary judgment by the bankruptcy court, and the settlement agreement, I believe, is your.
It's actually eight.
Okay. And the settlement agreement, I believe, is your Rainham Exhibit 9. Is that correct? Mm-hmm. Okay. Mr. Green, that settlement that you spoke about in the bankruptcy proceeding, did that conclude your dealing, so to speak, in relationship with Mr. Brennan at that point in time? Was that sort of the last vestige of the issues that you were dealing with?
The last vestige was in 1996, which was when his appeal was unsuccessful. So the bankruptcy issue was 4 years after that.
Right, right. After you settled the bankruptcy proceeding, did you notify the New Jersey regulators about the fact of your settlement and the outcome of the settlement?
Yes, sir.
And to your knowledge, have those notices to the regulators and the orders from the court been provided to the investigators from IEB?
Yes, sir, they have.
When they were notified about the outcome of these events shortly after they occurred, did any of the regulators, Casino Control Commission, Division of Gaming Enforcement, raise any concerns about the settlement as it pertained to your ongoing suitability to continue to participate in the New Jersey casino industry?
No, sir.
Let's move ahead a little bit from there. In the past 17 years, have you had any business dealings with Mr. Brennan?
No, sir.
You were involved in gaming in Pennsylvania as well, and I think involved in promoting the passage of that activity in Pennsylvania. Is that right?
Yes, sir.
Can you describe your role in that capacity?
Well, for obviously, my background is in the racing and wagering and gaming business, and I was concerned from Pennsylvania's position that various states, including West Virginia and Delaware, had moved towards allowing expanded gaming. And so I mounted, over a period of 8 or 9 years, a campaign to see if we could, in fact, bring expanded gaming into Pennsylvania. And eventually an act was passed in 2004. It didn't really take effect until the early part of 2006, but that campaign proved to be successful, and gaming in Pennsylvania has proved to be successful.
Mr. Green, you were licensed in Pennsylvania as a key employee, is that correct?
Yes, sir.
And is that the highest and most stringent form of license that you can obtain under the Pennsylvania Gaming Act?
Yes, sir.
Was the information regarding your relationship with Robert Brennan that you described earlier and that was contained in the suitability report here the subject of the investigation that occurred in Pennsylvania in 2006?
Yes, sir.
Have you had any suitability proceedings or license proceedings against you in Pennsylvania since you've been licensed there in 2006?
No, sir.
In the over 50 years that you've been involved in the legal gaming and wagering business in various countries, but most recently, obviously, in the United States, have you ever had your license denied, revoked, or suspended by any regulatory or law enforcement authority?
No, sir.
Did you hear today the condition that the director mentioned was suggested in the report to the commission that you agree not to have any business dealings with Robert Brennan?
Yes, and I'm already under that obligation from 17 years ago, so yes, I'm aware of that.
And I would ask you if you're willing to agree to that condition.
Yes, of course.
Okay. I have nothing further at this time. I'd reserve the right to redirect though.
Counsel?
Yes, good afternoon, Mr. Green.
Good afternoon.
I just want to clarify to the extent that I can for the commission some of the relationship that's been described this afternoon that you had with Robert Brennan. Yes. And just you know, by way of background, I understand that you first met Mr. Brennan in 1988. Was that when you were
around that time?
Okay. And you were, in 1988, you were the chairman and the CEO, I understand, of the William Hill organization?
Yes.
Which was, as I understand it, one of the largest wagering organizations in the world at the time.
Yes, it was.
Okay. And it was, and William Hill was a division of Grand GMet, is that what you call it?
Grand Metropolitan. It's now Diageo.
Okay.
Diageo, which is the largest branded drink company worldwide.
Okay, thank you. And then when you met Mr. Brennan around 1988, he at that time was chairman of an entity called ITB, which owned the Philadelphia Park facility. Okay. And then as I understand it, you testified earlier, in early 1989, you, Mr. Green, on behalf of Grand Metropolitan, and Mr. Brennan on behalf of ITB, were negotiating an arrangement to purchase Philadelphia Park.
Correct.
And it was a big transaction. It was $75 million, I think, was
yes.
the price you were talking about. And I take it, and you mentioned this on your direct, that Grand Metropolitan did a pretty significant amount of due diligence, or you referred to it as background checking,
Yes.
on ITB, but also on Mr. Brennan
Yes, indeed.
at that point in time. Were you involved in the due diligence exercise?
Yes.
Okay. And you indicated that, this I know is reflected in the Casino Control Commission document from New Jersey, that GMET, and I presume you learned that Mr. Brennan was something of a controversial figure because of some activities he'd been engaged in at First Jersey Securities.
Yes.
Okay. Now, would you agree with me, Mr. Green, that even at this earlier point in time, there was already a fairly significant amount of material available in the public record about some SEC issues that Mr. Brennan was having at the time of this transaction?
Yes.
Okay. And you indicated that it was your understanding from Mr. Brennan that nothing had really come of that earlier set of activity. I think nothing had come of it was your statement. Okay. But as it turns out, even at that point in time, that's not really true, is it, that nothing had come of it?
Not that I'm aware of.
Okay. Well,
I mean, here, sorry,
not that you're aware of. Okay, so just so I could drill down a bit there, were you aware at that time that in 1974, Mr. Brennan had already been suspended for a period of time by the SEC for inappropriate trading
yes,
practices?
that was part of the report from Grand Met.
Okay, so
But
it's really...
when I meant in terms of nothing has really happened, he had not been indicted or charged. He had been slapped over the wrist or by the regulators. Yes, we
Okay.
were aware of that.
I mentioned that he had been suspended in 1974. It sounds like you were aware of that. And in fact, in 1978, he was sued again by the SEC, and he agreed to the entry of a consent decree following that lawsuit. Do you recall that?
I don't recall it, but not specifically I recall that, no.
Okay. And then I think you referenced in your direct testimony another lawsuit by the SEC in 1985. That's the one that seems to have dragged on for a while, but was resolved later in 1995.
Yes.
Okay. And there was more, though. Are you aware that in 1986, Mr. Brennan settled a federal court case with the National Association of Security Dealers in which he was censured and fined for securities violations?
I can't remember it specifically, but I'm sure that came up in the due diligence.
Okay. If it was a matter of public record, it's likely that it would have come up in this
Yes.
process. Okay. And then he settled another federal securities fraud class action lawsuit in 1987.
Yes.
And then he settled another securities case with the National Association of Securities Dealers in 1990.
Right.
Okay. So ultimately, you testified that the transaction, the specific transaction that you had been negotiating on behalf of Grand Metropolitan didn't work out because of the situation with Pillsbury that developed.
Correct.
Now, is it your testimony that the Grand Metropolitan transaction with ITB fell apart for reasons that are completely independent of Mr. Brennan's
Absolutely.
situation?
Absolutely.
Absolutely independent.
Yes.
And it related more toward Grand Metropolitan's efforts to perform this hostile takeover of Pillsbury.
Yes.
Okay. So once that deal fell through, you then created GRI on your own. You left Grand Metropolitan, and you approached Mr. Brennan about doing the same deal, but doing it on your own as opposed to doing it through Grand Metropolitan. Okay. And ultimately, that deal closed in 1990.
Yes.
Okay. Now, I described to you a series of federal court actions involving security fraud allegations against Mr. Brennan that seemed to extend from 1974 was the first up until 1990. So, did you recall that?
Yes.
Okay. And then it would be fair to say that there was another period of time following that, 1994 to 1996, which were also pretty rough years for Mr. Brennan on the legal front with the SEC and others. Let me be specific about it. In 1994, there was a 40-day trial of Mr. Brennan on securities fraud charges that stemmed from the 1985 complaint that had been filed. You're aware of that?
Yes.
Okay. And then in June of 1995, the federal district court judge, following this 40-day bench trial, issued a final judgment in the case, finding Mr. Brennan personally responsible for widespread securities fraud at First Jersey. Are you aware of that?
Yes.
Any of you read that opinion?
Yes.
Okay. Now, there are just a couple of provisions of this opinion, and I think this opinion is not in evidence. I think the Commission could take judicial notice of it. It's 890, for the record, 890 F Sup 1185. The judge, if you've read the opinion carefully, makes a number of factual findings in the opinion.
Yeah, I mean, I read that about the time. I haven't read it subsequently, so
Okay.
I'm not.
One of the findings that the judge makes, and this is on page 22 of the opinion, is defendant Brennan is completely without remorse for the violations proven in this case, professing at trial that there was nothing wrong with First Jersey's pricing of the subject securities, and instead complaining that the prosecution of this action is, quote, in a sick way, comical, unquote, and is, quote, rooted in a malice and venom on the part of some people at the Commission, unquote. Do you recall that provision of the opinion?
No.
Okay. Then there's a further reference by the judge, and this is footnote 33, and I'll just read that into the record too. These comments, and that's referencing the comments that I just read, these comments by Brennan on the witness stand before me, however, pale compared to his remarks, televised at a First Jersey staff dinner following the filing of this complaint, this is presumably back in 1985, containing threats to SEC staff members and any of his own organization who turned against him. And then the opinion goes on from there to recite the threats that have been identified. Actually, they quote them. Do you recall reading either of those provisions at the time that you read this when it came out? Okay. I understand you don't specifically recall parts of the opinion when it came out and you read it. Would you agree with me that the opinion is pretty rough on Mr. Brennan?
Yes.
Okay. So then the next thing that happens in, following this 40-day trial in 1994 and then the civil judgment in 1995, in December 2006, the United States Court of Appeals affirms the fraud judgment in the SEC case.
Yes.
Okay. So for the period of time from 1994 to 1996, Brennan is tried, found personally liable for fraudulent securities trading activity, and then the fraud judgment is affirmed by the United States Court of Appeals.
Yeah, his appeal was unsuccessful. I think it was the beginning of December 1996.
That's correct, December 1996. So during this period of time from 1994 to 1996, Mr. Brennan's legal issues were, it sounds like, pretty well known to you. You were generally familiar with them.
Yes.
Okay. Yet during this exact period of time, it turns out that you also engage in a number of transactions with Mr. Brennan.
With the trust of one or two individual transactions, but specifically with the trust that he set up for his children. Yes.
Well, And actually, it might be helpful at this point. Do you have a copy of Exhibit 17 handy? This is the Casino Control
Yes.
Commission. Because I'm just going to allude to a couple of parts of that opinion because I want to make sure that we have some of the facts straight here.
Would you like the witness to have a copy in front of him?
That would be great. I'm just going to ask him a series of questions, and if he's having a problem recalling, I'm going to draw his attention back to the document. This is...
What number?
I don't
It's-
think we have 17.
I don't have a 17, I don't think.
It's
Oh,
in
this is...
the unredacted version.
It was Exhibit 17 to the IEB report, and it was attached to the version of the IEB report that was circulated to us.
All right, so we
It
don't
may
have,
not be in the book.
Okay.
okay.
It's not in the
We'll ensure you're provided with a copy. I don't think there's any... It's attached to the confidential report, but it's not a confidential document. In fact, I believe it's a completely public record. So let me just draw your attention, Mr. Green, to pages 6 and 7 of the opinion by the New Jersey Casino Control Commission. And on page 7 in particular, the first paragraph on page 7 begins in late 1994. Do you see that?
Yes.
Okay. Now, to summarize, well, let me just ask you a series of questions. In 1994, you, Mr. Green, personally bought a company called UK Food Products and Investments?
Yes.
Okay. And we'll just refer to the company as UK Foods. The last sentence of that paragraph reflects that even though you bought UK Foods with your own funds, the last sentence of that paragraph says, there is no dispute, however, that from November 1995 to November 1996, UK Food was used exclusively as an investment vehicle for Brennan. Did I read that correctly?
You read it correctly, yeah.
Okay.
That is not correct in the sense that any investments were made in respect of Pirate or the trust that was set up that was owned 75% by his children, but there were other investments that were made that were not part of that.
Okay. Well, just so the record.
I would just correct the word exclusively, and I would correct the word Brennan.
Okay. You mentioned this trust, Pirates, that
Yes.
was the name of it. 75% owned by Brennan's 3 adult children and 25% owned by Brennan himself. Yes. Okay. So how this came about that UK Foods was used exclusively for this investment vehicle for this trust owned by his 3 children and himself is that, and I'm referring to page 8 of the opinion now, it sounds like Mr. Brennan approached you, said he was having trouble making investments because of his problems with the SEC, and that he wanted to, quote, put a layer between himself and his investments. Is that a fair characterization of what that opinion says?
That's what it says. I wouldn't have characterized it in that way, but that's what it says, yes.
Okay. Well, put it in your own words for the commission, Mr. Green. How did this come about that you bought a company and then it seems to have been used exclusively by the trust controlled by Mr. Brennan's 3 children and Mr. Brennan?
As I said, not exclusively. There were investments that I had in that. I think the way I would characterize it, and I have to, I think you need to put it into context, that by this time I had known Bob Brennan for 6 or 7 years, that we had, through the purchase of Philadelphia Park and a subsequent purchase of the mortgage note that was part of that, that I'd been involved in approximately $100 million worth of transactions that involved Mr. Brennan. And there was nothing in those transactions that was, in my mind, they were all proper. He'd always, from my perspective, conducted himself, although he was, as I say, and as you have seen, a very flamboyant character. And so I had, from my perspective, notwithstanding the fact that he had this background of run-ins with the SEC, that in any of my dealings with him, they were all above board. You know, before I even knew him, we had a due diligence from a major public company and the people they employ, that we should in fact do business with ICB and that we should do business with Mr. Brennan. Within that context, and I knew Mr. Brennan, he said, should there be a situation where his trust lent money and my own to an investment vehicle that was mine, and I said, providing the investments we make can pay the interest and there is no recourse. And his view for us and me was, as you have said, that because of the current problems that he was experiencing, anything that was directly related to him should have a negative effect. And, you know, in retrospect, would I have been so, you know, accommodating? No, I wouldn't. But I think you have to put it in the context that I had known this individual for, you know, 7 years. We had done major transactions together. At that time, ICB still owned, for example, Garden State Park. It still owned Freehold Raceway. And I was also anxious to preserve that relationship because I felt that at some point in time it would be helpful from a Greenwood perspective that we would be able to acquire Garden State Park, which we didn't. We subsequently acquired the license and goodwill of that racetrack, that we may be able to acquire Freehold Raceway, which we did in conjunction with Penn National. So they were issues in the back of my mind as well, and I did not see, you know, at that time, anything that would not allow me to be accommodating in that respect.
Okay. Can you use that word? Let me just ask you a question, Mr. Green. You use that word.
Let me just finish. From my perspective, that had to come to an end the moment that his appeal was unsuccessful, and though any of those arrangements were unwound and terminated.
Following the December 1996 appeal?
Yes.
Okay. You used the word, you were accommodating your friend, and I, just drawing your attention to page 8, the Casino Control Commission uses that same language. The first full paragraph on the page ends with, applicant said he agreed to this proposal as an accommodation to his friend. Do you see that?
Yes.
Okay. And you were accommodating your friend to help him work around some of the legal restrictions that had been posed on him because of the SEC activity.
No, they were not to get round any legal restrictions. His characterisation was that while he was under the cloud of this appeal, you know, any investment activity or anything that he liked would be, you know, in some way regarded negatively.
So it wasn't a legal issue, it was a reputational issue in,
Yes.
in a way. Okay, that's helpful. As I understand the way the arrangement works, you purchased this company, UK Foods, with your own funds. And Brennan made the investments by loaning UK Foods money?
No, the trust.
I'm sorry, okay. The trust would loan UK Foods money. Mr. Brennan then personally would direct the purchase of particular securities with the money he lent.
No, some of them.
Oh, some of them.
Some of
Okay.
them, yes.
And then the only recourse that he had with respect to that loan was the value of the securities that had been purchased.
Yes.
Okay. And ultimately, the arrangement was such that Mr. Brennan would receive the benefit of those investments if they appreciated in value.
Yes.
That's the point of an investment, I guess.
Yes.
So, there was also a transaction, a similar kind of transaction involving a company called Care Advantage, Inc.?
Yes.
Okay. And as I understand that transaction, please correct me if I'm wrong, senior executives, principals at CareAd were desirous of having Mr. Brennan divest the shares he owned in CareAd, again, because of this reputational issue, I guess, that you've described. Is that fair to say?
This is 17 years ago, so I'm not absolutely clear as to all of the circumstances, but as I understand it, Mr. Brennan was a major shareholder in CareAd, which was a California health-based company whose primary contact, I believe, contract was with Blue Horizon. And that Blue Horizon had expressed concern of Mr. Brennan's, because of the case of his ownership of the stock. And what Mr. Brennan, if I recall, was that he divested of the stock principally to the two doctors who were actually, one was the CEO, something like Carrillo, I think his name was, and the chief operating officer, and also not significant, but a certain amount of the stock to UK Food.
Okay. Let me just try to put a fine point on that. Page 9 of the opinion, first full paragraph. The second sentence reads, according to applicant, and you're the applicant in this circumstance, correct, Mr. Green?
Yes.
According to applicant, Brennan had been requested by the principal officer of the company to divest his shares because third parties were refusing to deal with CareAd while Brennan was the owner. Brennan had become a liability to the firm. Did I read that correctly?
Yes.
Okay. So, Mr. Brennan approached you, and you ultimately purchased approximately 2 million shares of CARAD stock, correct?
According to this, I can't remember, but it was 1.3,
Okay.
not 2 million.
No, that's above. That's for Sonia.
Okay. Oh, okay. Sorry, I'm looking at the wrong paragraph.
Yeah, yes, it's 2 million shares of Care Advantage, and I believe you're referring to the next transaction that we want to talk about. And this deal was structured in a similar way. The purchase was accomplished of these shares was accomplished in return for a note, correct? Not cash, but a note.
Yes.
And this was, again, the note was non-recourse except for the stock itself, correct?
Correct.
And so again, here, Mr. Brennan would presumably reap the value of any increased value in the stock if the stock were sold, correct?
Correct.
Okay. And again, would it be fair to say that this was done like the UK food transaction that we described before as an accommodation to your friend?
Yes.
Okay. And then, very briefly, the next transaction, the Sanyo transaction, very similar. Again, here, the principal shareholder of Sanyo wanted Mr. Brennan to divest his ownership interest in his interest in the company.
Yes.
And so you bought, again, well, here you bought 1.3 million shares of stock, again, for a note, correct?
Yes.
Okay. And again, as in the previous transactions, the purchase was structured to enable the lenders, Mr. Brennan in this case, to reap a benefit if there was an increase in the stock value.
Again, I think this, essentially, yes.
Okay. And like the CARAD transaction and the UK Foods transaction, this was done as an accommodation to your friend, correct?
Correct.
Okay. And there were other transactions as well there are other transactions as well during this period of time between 94 and 96 involving Mr. Brennan's ITB stock.
Yes, between 1995 and 96.
Okay.
Yes.
There was a consulting relationship that you had with Mr. Brennan, consulting for an entity known as LVEN. Is that correct?
I can't recall if that was ever consummated or not. I don't believe it was, but I can't recall.
Now, you testified earlier, Mr. Green, that you were aware, and in fact you read the 1995 district court judgment involving First Jersey Securities and Mr. Brennan.
Yeah, I read that and the appeal brief.
Okay.
As well.
In it, there's reference in the Casino Control Mission report that not only did you read the appeals brief, but it sounds like you talked to Mr. Brennan about it. I think you testified that, and he seemed very, very bullish on his chances on appeal, to be fair to say. Okay, and actually, this opinion references a conversation with Mr. Brennan's lawyer as well. Do you recall that? Page 6. It's that paragraph beginning, the applicant was aware. And there's a reference there, it says, Brennan's counsel expressed confidence regarding the outcome. Maybe that wasn't a conversation, but it was some kind of communication with his counsel.
Yes, I think his counsel was Mr. Riccio, who was the dean of Seton Hall Law School.
Okay.
And I did have a conversation with him.
So it'd be fair to say that from your conversations with Mr. Brennan and your familiarity, you were generally familiar with the arguments that Mr. Brennan was advancing on appeal,
Yeah.
correct? Okay. Now, I'm going to read you a sentence from the Federal Circuit Court opinion affirming the 1995 order. And this is, again, it's in the public record, 101 F. 3rd, 1450, and it's page 16 of the opinion. On appeal, defendants do not challenge the court's factual findings as to First Jersey's business practices. Do you recall when you were talking to Mr. Brennan, had communications with Mr. Brennan's lawyer, reading the appeals brief? Do you recall any challenge to any of the factual findings that had been made by the district court?
What was challenged, and I forget the legal doctrine, was
Res judicata.
Thank you. That the events that were recorded in the judgment were of such a like nature to other transactions whereby he had not been found in any way on the wrong side of those, that you could not continue to bring like-minded issues before the court. It wasn't a question of challenging the fact of whether it was selling short a stock. It was the fact that if you had been had a complaint filed against you for that, and that complaint had been denied, you could not keep finding similar examples and bringing them to the court. So from my memory, the whole basis of that wasn't about the fact that somebody, it was about the fact that you could not continue to bring action after action on basically the same premise.
Okay. So
Can I object for just one moment? Only because we keep referring to this opinion, and I appreciate it's a matter of public record. I do not have a copy of it. I have not reviewed it. I understand where the line of questioning is going, which is why I haven't objected. But I think at some point it's inappropriate, given that it's not an exhibit. We don't have a copy of it. It's consistently being referred to. Now we're getting to the legal merits of that opinion, which clearly Mr. Green is not an attorney. So I think it's no longer appropriate to keep referring to it, and most definitely disadvantages us from a legal perspective as far as counsel is concerned. And I'm not trying to be difficult, and I have been very patient, so I apologize, but I just would ask if we're going to keep referring to it, we should have copies of it.
with all due respect to Ms. Lee, the witness has identified in direct testimony both careful review of the district court opinion, understanding of the appellate process, and an understanding of what the Court of Appeals said. And I think it's perfectly appropriate for the Bureau's lawyers to inquire as to his understanding of the issues that were raised by the district court and by the Court of Appeals.
And I'm not disagreeing that it may be appropriate. What I'm opining about and objecting to is that, as counsel, I do not have a copy. Had I known that it was going to be addressed at length, I would have, liked the opportunity to review it.
Does this get cured by creating another copy or two, or however many you need? Does that solve the problem?
I just don't, and perhaps he's,
Yeah.
Mr. Mackey's not gonna go much farther
I'm-
and maybe a mood issue, but it's just at some point, we keep referring to a document that I haven't reviewed.
I'm done with
Okay, and thank you.
the opinion in the Court of Appeals.
Okay.
I might reference the date that it came down, but
I have no
I
doubt.
promise that's it. So what I'm interested in, Mr. Green, is that it sounds like you understood, because of your familiarity with the arguments that were being made on appeal, that they were arguments that were in many respects oriented around this res judicata point that you very ably described. But you knew at the same time that Mr. Brennan's appeal wasn't involved with challenging the facts that were laid out in the district court opinion.
That's true, that's about the opinion.
That was your understanding? Okay. The opinion comes out in December 1996, and it sounds like that was sort of a significant event in terms of your relationship with Mr. Brennan.
Yes.
Okay. Between December of 1996 and then at the time when the New Jersey Casino Control Commission opinion came out, which I think was March 2000, could you describe for the commission what your dealings with Mr. Brennan were during this 4-year period of time?
No.
Because there weren't any?
Yes.
Okay. No personal
No.
friendly visits or anything like that?
No.
Okay. No contact with him for that
Oh,
period
no,
of time?
I said no business.
No business, okay.
Yeah, I met him on a few occasions, yes.
Okay. Could you describe those occasions? What did they involve?
I think that,
Closer to the mic.
oh, sorry. A couple of the conversations related to the purchase originally contemplated by Greenwood for the acquisition of Garden State Park and Freehold Raceway, which was still owned by ICB. So certainly I had conversations with him about those matters, yes.
Okay. And that was during this period of time, 96 to 2000?
But I think it was in I'm not quite sure of when the purchase was completed, but I think it was in 98 or 99.
In any case, following the...
Yes.
Okay. And then you referenced one of the conditions imposed on you by the New Jersey Casino Control Commission by that opinion, and that was to have no further contact with Mr. Brennan?
No, it was when the conditions was no further business relationship with
All right.
Mr. Brennan.
And has there been any further business relationship with Mr. Brennan since March of 2000?
None.
Okay. And what about personal contact, friendly contact since March 2000?
When he was incarcerated in Fort Dix, I went to visit him a few times, and since his release from Fort Dix, I think 2 years ago, I've seen him on a couple of occasions, one of which was when we were separately invited guests at a function.
Okay. And anything further since?
No.
Okay. There's been a lot of reference to the New Jersey Casino Control Commission report, which is in evidence. When you you review that report when it came out?
I'm just going to ask, are you talking about the
Exhibit 17.
opinion? Oh, 17,
Yeah,
okay.
sorry. Did you review Exhibit 17, that opinion, when it came out?
Yes.
Okay. Did you dispute the findings in that opinion in any way? Did you file an appeal, for example? Did you object to it?
I think this is the chairman of the commission's, if you like, findings of. I wouldn't say I would agree with every line, but the general characterization of it, yes, I would agree with.
Okay. And so you didn't file any objections or appeal from that opinion?
No.
If you know. No. Okay. I have no further questions.
Commissioners?
Mr. Green, I just trying to understand your standards for doing business with someone. If you were found suitable and afforded a license here, you would certainly have new business relationships, and I was concerned or just interested in what your standards are for doing business.
Well, I have done business in this industry for 50 years. As you can imagine, the number of transactions that takes you from one licensed betting office in North London to becoming the largest wagering business worldwide, there are hundreds of transactions and you're dealing with hundreds of entities and people. All I can say in regard to this affair, if you like, was that in the dealings that I had, as I say, the acquisition of Philadelphia Park, the acquisition of a mortgage note, the subsequent acquisition of Garden State Park and freehold. In none of those transactions was there anything that would suggest, certainly from a corporate point of view, that there was anything wrong with those, or I had any reason to doubt the word of the person I was dealing with, who was, at the time, a chairman of a public company. So, one, sort of treats people as one finds them, and generally, in the transactions that we have done here in the US, I believe speak for themselves.
I guess what gives me pause is the fact that you said that you were aware of lawsuits, allegations, suspensions, and then, of course, we get into convictions and you still continue to do business. New Jersey ordered you to stop doing business with this individual. It just seems to me that
well, they made it
it brings three different gaming commissions, brings your reputation in question, and I'm just.
Well, I think it was a condition which there was no need for that condition, because the minute that appeal was unsuccessful, I terminated any business relationship anyway. So from the view of the New Jersey Commission, or a condition 17 years ago, was one that had already was in place in any event. So in that respect, the condition, if you like, that is being suggested is a condition that I've happily complied with for the last 17 years.
If he had been successful on appeal, you would have continued to do business, even though businesses anywhere else had stopped doing business with this
No,
individual?
I think that it was, if you like, a turning point, but in any, if you like, I saw that had to be terminated, but in my view, that was going to happen in any event over a period of time, because for the same reason, from a perception angle, in my view, in retrospect, I should have been more appreciative of the fact that it may have been perceived negatively, and so therefore that would have ended in any event.
Thank you.
Commissioner McHugh?
You've been very helpful in answering Mr. Mackey's questions, and I don't want to go over those transactions in any detail. I would just like to spend a couple of minutes trying to put them in order, so to make sure that I understand sequencing. You bought Philadelphia Park in late '89 or 1990, is that right?
1990, sir, yes.
And by that time, during the due diligence, you discovered the various SEC interactions, let's call them, with Mr. Brennan that Mr. Mackey described to you in the questions. Is that right?
Yeah, they mainly came out of Grand Met's
Due
due
diligence,
diligence, yes.
right. And as part of that transaction, ITB, from whom the tract was purchased, took back a purchase money mortgage. Is that right?
Correct.
For about $56 million?
Yes.
Something in that vicinity. And that had, when was that finally paid? Or was it? Approximate time, I don't know, I don't need exact.
I think it was 3 or 4 years after that.
All right. In 1994, you were aware that this 40-day federal court trial took place.
Yes.
And you must have discussed that a few times, at least with Mr. Brennan, that 40-day trial is an ordeal, isn't it?
I can't remember specifically
Right.
at that time, because I would assume that took up all of his interest.
But it was at the end of 1994 that you purchased UK Foods, is that right?
Yeah, I think it was in the autumn of that year.
All right, so which was the same year as the
Yeah.
trial. And it was in early 1995 that you bought the shares of Sanyo Trust from the trust.
Yes.
And that you understood was necessary because the owners of Sanyo wanted the Brennan interests out of the company.
That's,
The trust.
I think I'm not sure of where that information came from. I think it was from the,
From the New Jersey hearing.
yeah,
That's where I got it.
I'm sorry.
I think
no,
I think he was talking about there was a different stock regarding, I think you may be referring to a different stock that he
This-
testified about. I don't think he testified about the Sanyo.
Well, then let me ask about the Sanyo transaction. Did you, in early 1995, buy shares of Sanyo from the trusts?
the
for the-
UK Foods, yes.
Yes.
I did.
And you bought those because, again, Mr. Brennan told you that the owners of Sanyo wanted him out of the country, out of the company, because of the difficulties he was having with the SEC.
That was supplied, I think, by the accountants of ICB. I'm not sure of their name, but or the partner who'd asked if we were interested in, having a position in that stock. I can't remember the full details, but I believe the company was in the process of dividing into 2 halves. One was, I think, an automotive division, and another was a pure spare parts division. But I can't remember that
Well,
detail very clearly.
the hearing examiner in Exhibit 17, and I don't have a page reference, found that, or said that you bought that stock because you learned from Mr. Brennan that the owner of Sanyo wanted you out of the company, wanted him out of the company because of the controversy. Is that inconsistent with your recollection?
It's page 9 of Exhibit 17.
No,
That's not inconsistent with your...
no.
All right. And that was a non-recourse transaction in which you paid with a note, and the securities were the only recourse for non-payment of the note.
Yes.
Is that right? And when the securities were sold, the rise or gain or loss would go to the trust.
Yes,
Right. You became a shareholder of ITB in April of 1995 as well, right? That's the transaction involving the interest in the Ireland property,
yes,
and you remained a shareholder thereafter
yes,
until at least after the appeal was decided. Is that right?
yes,
You entered into a consulting agreement with a company called LVEN in May of 1995. Is that right?
that was the one referred to.
Right.
I'm not sure if that agreement was ever consummated. I remember it being discussed, and that I did some consulting work for a projected venture in Nevada, and but I can't recall the full details of that today, whether it was actually consummated or not, that particular agreement.
Do you recall a transaction in whether it was this one or not? And again, that my reference comes from the New Jersey hearing. And again, I regret I don't have the page number because I don't have the document in front of me. An agreement with an entity in which you were to provide consulting services and Mr. Brennan fundraising services.
That was the
Las
basis of it. Yes.
Yes, and Mr. Brennan negotiated the deal in return for 100,000 shares of stock, which would go to you with the understanding that he'd get half of that.
I'm not sure of the details of that, but that sounds.
And
about-
but his name did not appear on any of the on any of the documents recording and reflecting the transaction.
As I said, I can't remember whether that was actually consummated or not.
Does that kind of an arrangement sound familiar to you, whether it was ultimately consummated or not?
It could be, yes.
Okay. And then the CARAD transaction took place a month later in June of 1995.
Yes.
And then in that same month, the trial judge in the Securities and Exchange Commission case issued his opinion.
In
June of
in
95.
June, yes.
Yeah, and you read that opinion.
Subsequently, yes.
Yeah. So all of these transactions that I've just described and that Mr. Mackey went into with you in some detail and that you were helpful in responding to him with took place between the trial and the judgment.
They took place, the three that you referred to, between, I believe, January and June of 1995 or 6. Yes.
Did it ever occur to you at any time during that period that Mr. Brennan was using your good offices as a mechanism for hiding assets from, in anticipation of an adverse judgment?
No, my view was that, in fact, the dealings mainly were related with the trust, and the ones that were with him directly, he had made his position clear to me. Would I have invested personally in those? No, because it was a non-recourse situation. There was a published note would I have, if you like, looked more carefully at that situation with the benefit of hindsight? Yes, but from my perspective, I didn't see anything specifically improper in what in his action.
In 1996, shortly before the appeals court judgment came down, you were a shareholder still of ITB, is that right?
I believe so, yes.
And there was in ITB, there had been in ITB a proposal by some shareholders to create a shareholders' rights plan. Do you recall that?
Vaguely, yes.
Yeah. And do you recall that Mr. Brennan opposed that? He too was still a share, that's two questions. Mr. Brennan was still a shareholder of ITB at that point, is that right?
I don't know, I assume he was, I don't know for sure.
Do you recall him being opposed to the shareholder rights plan?
Yes, I think I do.
And do you recall him seeking to remove the directors who had proposed the shareholders rights plan?
Yes.
And do you recall voting for the removal?
I think the majority of shareholders voted against the shareholder rights proposal.
Right, including you.
Including,
yes. Yes. All right, that's all I have. Thank you. Thank you very much for your help.
Mr. Zuniga?
Just a couple of questions. On your early dealings with Mr. Brennan, is it fair to say that you had a number or a couple of successful and profitable transactions with him?
well, the most significant transactions by far were the acquisition of Philadelphia Park. I mean, it was a very significant, certainly for me and my fellow investors, including our major investor. They were, major transactions, and obviously presented a great, significant amount of risk. As Philadelphia Park, when we acquired it, was losing money as a racetrack, but we managed to make it into a very profitable organisation, mainly with the development of the racetrack, the off-track wagering facilities that were actually our expertise, which were regarded as the best in the US, and the development of the telephone account wagering system, which was again the major system in the US. So, coming back to your point, sorry, I've put me in the houses, but that was probably the most significant and profitable transaction. There then was the repurchase of the mortgage, which occurred, and then there was the purchase of the lease and the goodwill of Garden State Park Racetrack, which proved very successful, And then there was the joint venture with Penn National for the purchase of Freehold Raceway, which, although not as successful as the others, was still a beneficial transaction for us. So certainly, in terms of overall, the panoply of transactions with ICB, which probably added up to $150 million, they were all, in my view, very successful, yes.
Would you say you owe Mr. Brennan anything personally as a result of those successes?
No, not at all. Not at all.
Would you say the reverse, that Mr. Brennan owes you?
No, I don't know. I would not look at it. The transaction was the transaction, and I go back to the old adage from previous that in a transaction that is successful, both parties are slightly dissatisfied.
Thank you.
Mr. Stebbins?
Sure. Mr. Green,
Sure.
is COO of, part owner of Greenwood Racing, and you're obviously a part owner of the applicant for Raynham Park. What do you see is your potentially your day in and day out involvement in the operation of a slots parlor at the Raynham property?
I think the first thing is you probably have gathered from the testimony of our CEO, Mr. Riffy, and our counsel, Mr. Boner, and hopefully me, that we're passionate about this business. We are committed to it. We will, in the same way that we did with parks, we'll bring everything to that party. What I contribute and believe I have contributed is a sense of vision and strategy and a creative element to how we maximise that business. Clearly, a significant and major partner in our business is the Commonwealth. So, in the same way as they are in Pennsylvania, we can say that the Commonwealth of Pennsylvania is a 60% shareholder in that business. That is, without obviously any capital investment or whatever, that we pay a very significant amount of gross revenue directly to the Commonwealth, as we will to the Commonwealth of Massachusetts. So we are very excited about that prospect. We're committed, we're passionate about the business. As Mr. Bob Manutian pointed out, any business that we become involved in has been successful, whether it's on the racing side, the gaming side, the technology side, the export of racing from here throughout the world via one of our companies. So my view is that I'm certainly what I hope to bring to the business in Massachusetts is the expertise and the knowledge that we have learnt from our business here, and also for the fact that I was the joint chairman of casinos going back to the 70s and 80s in London. So it's a business we know and we understand, and we deliver.
There's information that, and I probably could ask ask Mr. Bonner and Mr. Ritchie this question. The creation of a Raynham Park Advisory Board, of which I only find at least one name of one person being appointed to that advisory board. Do you have thoughts or ideas, or other parties you can mention who would be part of that advisory board?
Not at the moment. We're discussing that internally with our partners, and I'm convinced that it will be an appropriate group of people that will ensure the success of Raynham, as undoubtedly it will be.
One final question, and I know we've obviously had a lot of dialogue this afternoon about your relationship with Mr. Brennan. Have you, in your business dealings and business transactions, ever approached a potential business partner who was invited to participate in a venture and declined over their concern of your relationship with Mr. Brennan?
None, sir. None.
Thank you.
Mr. Green, I'd like to ask what is the makeup of the audit committee of Greenwood? I forget which Greenwood entity is the principal controlling entity, but Greenwood Raceway?
Racing.
Yeah. What's the makeup of the audit committee? This is the one that you're the chairman of the board of.
Yes.
Correct? Yeah.
I'm chairman of the board, but I don't sit on the audit committee. In fact, I don't really get my facts wrong, so I would defer to Mr. Bonner, but certainly I get reports from the audit committee, but I don't sit on that board. I'm not quite sure who the current members are, apart obviously from our chief financial officer, Mr. Brian Bartlett. I'm not sure who chairs that committee at the moment, but
For the record, the members of the audit committee are the same as the members of the compliance committee, which Mr. Bonner testified.
Everett, Kendall, and
Bud.
Right.
but yes, sir.
There's never been any intimation that I'm aware of about any inappropriateness, any integrity issues with your companies. Nevertheless, in the business that we're in, having compliance committees and audit committees with genuinely outside people who aren't afraid and aren't financially penalized to be skunk at the garden party seems to me like it would be a worthwhile investment. Just the kind of additional protection that would, in the long run, be in everybody's interest.
Yes, sir. I think from our perspective, the outside directors who actually sit on compliance and audit, specifically Mr. Everett and Mr. Budd, are truly outside individuals, in the sense that certainly Mr. Budd, who was with banking corporations for 30 years, is very, in the terms of compliance, I know, extremely independent and rigorous. When I read the minutes of those committees, certainly give me comfort of the fact that they are independent and not afraid to ruffle the feathers of director or executive directors. But I take on board the point that you're making, and I think we should certainly give it careful consideration, sir.
Thank you.
Mr. Chair, one more
Yes.
question, and repeat a question my colleague asked earlier. Where is home for you, Mr. Green?
Sorry?
Where is home for you?
Philadelphia, sir. I've lived in Philadelphia since 1989, and my permanent residence is there.
Okay.
Except for a question which I'll ask in a minute, as I read about all these transactions with Mr. Brennan during this period of time, they seemed not terribly remarkable to me, although, as I say, I have a question about that. But the one that did was this one about Green purchasing 425,000 shares of ITB for $1,275,000 in return for 620. And apparently, all you can remember about that transaction is that you woke up after dinner, having drunk a lot of wine, and all of a sudden, you owned $500,000. Tell me what was going on there and what that says about your business acumen.
Hopefully that was a one-off situation. I should point out that as Greenwood ourselves, we acquired some stock, not a great deal, but a certain amount of stock in ICB, simply because they were a public company. We wanted to get their filings with the SEC. We wanted to get their prospectus, their annual general report. And I knew, and then a few years later, a situation arose socially with Brennan where he would have liked to have seen me have a more, or advise ICB more about the direction of the company, because although he was a prolific racehorse owner and breeder, he didn't really know too much about running, a racing or pari-mutuel business. And again, I didn't see any problem with me owning that stock. And again, it was, if you like, part of a framework where I wanted to maintain that relationship, principally because I saw in ICB assets that ICB still owned that I felt would be very good potential acquisitions for Greenwood. So it was within that ambit that took place.
I hope maybe you and I can have dinner sometime. I just have three more questions. Up until just now, when you were answering Mr. Mackey's questions, my perception of this transaction with Brennan was that you were, that this person was a friend. As you said, your business transactions had been, so far as you could tell, with him on the up and up. And that, frankly, you were bamboozled by him, as many people were bamboozled by him and his asserted good intentions. What I thought was significant was that you never profited by any of these transactions where you were helping him protect his investments and his assets and so forth. But today you said that one of the motivations for doing those things, making those accommodations, was that you wanted to maintain the business relationship with him in order that downstream you might be able to consummate other deals, which in fact, having maintained that relationship, you did. Did your judgment, did your wish to consummate other business deals cloud your judgment about behavior you might otherwise have thought inappropriate?
I think that's a good point, in the sense that, as I said earlier, with hindsight and sort of in retrospect, what I believe I should have appreciated more was the, if you like, the perception of that, as opposed to the actual reality of it. Clearly, I was very disturbed at the outcome of the appeal and had to immediately, from my perspective, unwind any transactions. But in the time between that unwinding and the bankruptcy case of 4 years, during that period, although I had no business relationship whatsoever, I still managed a social, would speak on the phone and asked after his children and his grandchildren, and maintain that sort of contact on the basis that one day that we may be able to do other transactions. So, I wouldn't disagree with your interpretation of
Well,
that.
I appreciate your candor about that. If in the course of our investigation about this application, we found that Mr. Manukian's investment was substantially a front in effect for some other investor who had been convicted of serious fraud by the SEC and whose reputation was very damaged therefore, would you think that we would find Mr. Manukian suitable?
No, you would not.
And that's distinguished how from this situation?
In the sense that I would, as I said before, the reputation and the knowledge that I had of Mr. Brennan, and there was no secret of the fact of his controversy that accompanied him, and the flamboyant nature of his character. But to set that background, there were at the hearing in front of the New Jersey Casino Control Commission, there were many people who came to testify in that matter, and I remember a great majority of them had in fact had business dealings with Mr. Brennan, and I remember one particular witness, the gentleman who owned Atlantic City Racehorse, who actually said he doesn't really know any prominent businessman in New York, New Jersey or Pennsylvania who'd not had business dealings with Bob Brennan. So, coming back to your question, I don't see the two things as being the same, and certainly there was no, at that time, no finite verdict as to the charges, the civil charge that had been filed by the SEC.
I think it's distinguishable, but I think it's also instructive, the parallel. This is my last question, and I must say I'm puzzled by this. On the one hand, I'm struck by an incredible assertion of loyalty to an apparent friend, even when this person was in jail, apparently, and you haven't taken a fair amount of grief for being associated with him. You went to visit him in jail, probably not all that common a transaction in his life, and subsequently you have apparently seen him socially. You've never really spoken ill of him. You've said repeatedly, I wouldn't do this again. And you've been candid about some maybe misjudgments that you made. But I don't get any real sense of regret that you really got taken to the cleaners by a guy who probably, in many respects, at least in his business life, a pretty bad guy. And I can't figure out, are you just very loyal to this man, which on the one hand is a very admirable trait, or are you failing to see what everybody else is seeing, and that's a problem?
I think that's a fair comment in the sense that my visits, as I said, and it's clear, I've had no deep friendship or any business relationship with Bob Brennan for 17 years. the fact that I felt that his incarceration, it sort of resonated with me, that somebody who, you know, enjoyed the company of presidents and lived a particular lifestyle was in a place like Fort Dix. And I guess it was more of a humane situation of, you know, he's a man for all that, and you know, I regret, as you say, remorse, I think, would be too strong a word, but certainly I regret that. But my visit, you know, the occasional visits I paid were really just as a man to a man, a man who's a father and a grandfather, and you know, you get an hour to sit and talk about, you know, things like that. Obviously, you know, the business element was, you know, dead and buried.
Okay, thank you. Any further cross?
No, no further questions.
Or I guess redirect, sorry.
Okay. I'll be very brief if I can. And I appreciate all of the comments. Mr. Green, if you would just look at page 18 of the decision by Chairman Hurley, who was listened to the days of hearing that were held on all of these topics that we've covered in some detail today. At the beginning of the second paragraph, it says, and I quote, "It is noteworthy that Brennan's improper conduct did not involve any of the business deals he had with applicant." And then if you go down 2 sentences, it says, "He undertook these deals, particularly those involving pirates, as an accommodation to his friend. But at no time did applicant knowingly engage in any attempt to aid Brennan in hiding assets, nor did applicant foster any illegal scheme of Brennan." Do you agree with those conclusions by the chairman?
Absolutely.
Okay.
Could I interrupt for a second? We've referred to that Exhibit 17 to the IEB report a number of times. We ought to mark that, don't you think, as an exhibit?
In fact, we do. I didn't appreciate the fact that we wouldn't have it here before us today, so we've got copies
I don't
of
mean
it.
to interrupt you. We can do that
problem.
later. I just wanted to not forget it and
Okay.
make sure
I
that
can hand out copies when we're completed here, given the amount of attention it's
I'm
gotten.
sorry, I would
No
have forgotten
problem.
it if I didn't interrupt.
So, Mr. Green, given the notoriety that arose back in the mid-90s and your involvement with Mr. Brennan, and the fair comment and critiques that you've heard here today, which you heard back in the mid-90s from other regulators as well, and again in license application some years later in Pennsylvania, given the opportunity to have a chance to do these relationships over again, for that 18-month period back in that time, is that something that that you regret doing?
Yes.
And have you, so to speak, learned your lesson from that experience?
Yes.
Okay, that's all I have.
Recross?
Nothing further.
Commissioners, anything? Mr. Green, thank you very much. We appreciate
Thank
your
you.
time and candor.
Thank you.
Yes, let's take a 10-minute break or so, and we will come back and meet the patriarch of the family. All right, we are reconvening the adjudicatory hearing on the Rainham Park LLC application for a Category 2 license. Counselor, you had a...
The Bureau proposes to introduce Bureau Exhibit number 5, the same document that is Exhibit number 17 to the unredacted investigative report. It's a public document, and it got a tremendous amount of attention, so we felt it should be part of the official record.
Is that all right, Counselor?
There's no objections. It is part of the exhibits that the commission has already received.
Right.
So we have no objections to
Right.
including as the part of the medical exhibit of the adjudicatory hearing.
Okay. Thank you. Before we start, we have found a spare cell phone, an iPhone, It was over in this corner. Janice Riley has it in the back. If anybody's missing a phone, or if later on somebody says to you, "Oh my God, I can't find my phone," we will take it with us tonight and have it at our offices. Okay, so you ready? Counselor, I think your turn.
I will reintroduce myself to the commission. I'm Joel A. Kozol. With me is Michael Maurizio and David M. Kozol. We are all of the firm of Friedman and Atherton. I and my firm have been counsel to George Alcani for the last 56 years. As a preliminary matter, I would state that at the very useful preliminary meeting we had with your council, they raised a single issue for clarification and potential resolution by Mr. Carney. It related to an isolated and unrelated real estate tax matter. I would tell you, the commission, that that has been resolved. It is, I am told, item 10, Exhibit 10 to the Raymond application, and I would suggest to my counsel and the commission that that issue is now moot. With that introduction, I'm going to call upon Mr. Carney, who will, in the tradition that seems to have been set, tell you where he was born, where he has lived his life, something about his business career, why he formed this venture with the Greenwood people, and why he thinks that they meet the requirements of suitability and indeed are the preeminent application for the slots license. Mr. Carney.
I want to thank everybody. This is an opportunity. Believe it or not, I've waited for 20 years. And at different times in my life, I thought, well, Jesus, will you make it? Because I'm 85 now, and I said, if I got to go another 20, I got no shot. But anyway, I appreciate everybody giving us the time to be heard. I have had a very exciting life. I've had great health, and I've enjoyed myself for a long time. As Joel said, that he and his father picked me up when I was a very young fellow at the time. They kept me on the straight path. It was great. I was fortunate. I had two fathers, his father and my father. So anyway, I've had a lot of experience in the racing business, none in the casino business, but in my years in the race, and I started off very young at the age of 14 years of age, working as a lead out at the Rainham dog track that my father was involved with. At that time, believe it or not, I was making $4 a night. That was more money than most people that teach in school were making. So it kind of put me in the idea I want to stay in this business. It's pretty good. I went as far as the 9th grade in school. I got out of school when I was 16 years old, so you can see I wasn't too good of a student. But anyway, I always had the ambition to be successful and to work hard, and which I've been able to do. I've gone into many businesses. Some I wished I hadn't, but my track record and overall has been better. And I've enjoyed the racing business the most of them all, because it's always been a fascinating business. In my past, I ran the Brockton Fair, which I still own. We had horse racing there. I ran the Middleborough Fair, which I still own. We have dog racing there. And at one time, I owned the Weymouth Fair. We had horse racing there. Then we moved it to Rainham and had dog racing there. So, and also during all my younger years, I was the general manager over the Suffolk Downs when the late Joe Lindsay and a fellow from New York owned it by the name of David Haber. And I also worked at Rockingham Park when Lou Smith owned it. So most of my life has been spent in the racing business, with very few exceptions. And after that, I've gone into many other businesses, the trucking business, construction, real estate, and also in many businesses. I'm not sitting here to tell you about how good they've all been, because some have been good and some haven't been good. But anyway, this time of my life, I finally felt that I had an opportunity to do something that I've been trying to do for the last 20 years, is to see if we could get the casino a bill through the legislature whereby we could bring a lot of jobs back to Massachusetts, bring millions of dollars back in taxes that they need desperately. And the result of the thing was that I finally made it. I'm here today. As far as that's concerned, I feel this way here. I got a great location. It's got a great road network. I had many different people I talked with about along the way who I was going to be involved in partners with. I talked to the Indians. I talked to this one and that one. And finally, I went to New Jersey, down to Philadelphia, and I met Tony, and I met he went there, and I met his wife. And then I went to New York and met Bob Manukian, and I said, this is where I belong with these people. I got a lot in common with them, and that's the reason why I decided to go along with them. I'm here today hoping that we will be able to put a successful application before you people, one that you will be able to look favorable on as far as the thing is concerned, and hoping to create a lot of jobs. I live in Brockton. I have a lot of people in Brockton that worked at the track when we had live dog racing. Also, we had a lot of people in the city of Brockton with Rainham, all the area there. We a lot of times had more people working for us than we really needed. But it was one of those things. It was awful hard for me to turn somebody away that needed a helping hand. And anyway, I feel this way here that we can run a great operation, one we'll be proud of, one that you people will not be unhappy about granting us the opportunity and giving us the opportunity to do how well we can do, and to show you if there's any questions that I can answer, I would be happy to, and I won't take it long. I know you've had a long day here already, and here I am. If I can answer them to the best of my ability, I will. And thank you for giving me this opportunity.
Mr. Connie, I think it might be helpful if you just supplemented those comments with what has been your relationship with the town of Raynham and the surrounding towns, the police, the firemen, and the people who have worked with you and for you.
I have a great relationship in the town of Raynham. We've had 2 public hearings down there. We were well received. We went before the Board of Selectmen. We made a deal that was very, very good for the town. The town is going to get around $4 million a year at least, and go up over the period of time. We're going to be able to take care of a lot of people that live in the town. I have a great relationship with the fire department, the police department, all the town officials, the selectmen. They know George County. They know what to expect from me as far as the thing is concerned. So I really don't have, really from what I can see, any objections to where we want to try to go, and how we're going to get there. That's a different issue. But anyway, as far as the thing is concerned, I know that in the city of Brockton, we have a great reputation. I still run the Brockton Fair there. And anyway, that's about everything I have to say at this time. Questions? I'll be very happy to answer any that I can.
Thank you.
Counselor?
The Bureau has no questions of Mr. Carney.
Commissioners?
I have no questions, Mr. Carney.
Mr. Stebbins?
No.
I'm just curious, Mr. Carney, what are your principal operating businesses at the moment, setting aside this one?
Right now, I run a trucking company that's been very successful. We cater to the utilities, mainly, National Grid, the telephone, we kind of restricted it to that kind of an operation because it was one that you didn't have to worry about getting paid. My companies are all union, which is very important. We've been involved in the Teamsters Union for many years. I've carried a card myself in the Teamsters. My son Christopher's in the Teamsters. My nephews are all involved in the Teamsters. That's one business that I'm very proud of. I've been in the liquor business, in the package store end of the thing.
And that's
real estate.
That's still extant? I was looking for the current.
My wife is taking care of that and involved with that, and my daughter Mara. I didn't have enough time to spend with it as far as the thing was concerned, and I thought I would give my wife something to think about when I wasn't home. Thank God she's not here today, and hope she's not listening.
All right. Anybody else Further questions?
No.
Anybody else further questions? No. Cross, direct?
I just would add, when you ask the other businesses, he's referred to it, but he is, what is your relationship with the Brockton Fair?
I still run that.
And you're the majority stockholder?
Yes, I've run that since I took it over as a young fellow at 28 years of age in a proxy fight that his father helped me win and gain control of a corporation that was founded in 1874. As a matter of fact, I ran 1874. No, I'm right on that one, Joe.
Okay.
I fought that issue before. And I ran that operation in the past, ran harness racing, ran very successful. James Cagney, the right move, he acted back in when he used to have a home in Martha's Vineyard, and he used to come in the summertime and race his trotting horses there. Then after that, we went into the flats, and I ran thoroughbred racing there back in the early, in the 2001 or 2 in that area there. We had, unfortunately, had a bad tax bill that we couldn't operate under. But that's one of my favorite places. I just came back from there. I'm kind of a hands-on operator, like at the dog track. I okay all the bills, I sign all the checks, I watch where we're spending for the money, and I'm sorry, I live in the same home, believe it or not, in Brockton, which a lot of people come to take a second look at me in the business world. I bought it when I was a young man for $38,000. I fixed it up quite a bit through the same years, and I still live in the same house. I never got too high up and too high and mighty, and I live sort of a simple life, I guess you'd say it, but I'm happy at it. And thank you for your time.
Thank you, Mr. Carney, and thank you for your perseverance in this venture.
It's been a tough life, but it's worth it.
Thank you.
Thank you very much.
Well, nice to see you. Yeah.
Mr. Carney, nice to see you again.
Nice to see you.
It's fine.
George. Okay.
Thank you, Mr. Carney.
Commissioner, it's appropriate. Thank you, Mr.
We're
Thank you,
flexible.
Mr. Carney.
Okay.
Oh, Mr. Carney, yes.
Yeah. Yeah, well, I think he's all right.
All right. Counsel for the applicant, would you like to make a closing statement?
I believe Council Keller will be very
Okay.
Just very brief, Chairman and Commissioners. Thank you for the opportunity to appear before you today. We certainly believe we've amassed a huge record here, not only the record of the proceeding today, but the mass of materials and evidence that we provided to IEB over the course of an investigation. We certainly believe we've met the clear and convincing standard for suitability for the entities and principals involved. We hope, we're glad you had the opportunity to meet and question our principals today. I hope that was useful to you. Some of the evidence that was hashed out today has been hashed out by other regulators in the past, and we certainly ask you to take note of that under a virtually identical statutory standard. And with that, we look forward to submitting a Phase 2 application, and thank you for the opportunity.
Thank you, Counsel. With that, sure.
I may have missed this, but have we formally introduced all 11 of your exhibits? We have them. Have they been? Have we just said they're all 11 or?
We have introduced our first 5, and I know that some of yours were introduced during the witness testimony. I'm not sure whether you picked them all up or not, though. So, and we certainly have no objection to any of them.
We had pre-filed or pre-submitted 17.
Yeah, I believe it was 17, but in any event, at this time, we would move to have Raynham Park LLC's exhibits and supplemental exhibits numbered 1 through 17 entered into evidence today prior to closing. Thank you very much, Commissioner McHugh, for reminding us.
And we have no objection.
Okay, thank you. So with all that, we will conclude this portion of the suitability proceeding. The Commission will deliberate about the matter in private and issue a written decision. The proceeding at this point, however, remains open. If at any point during deliberations the Commission determines that further testimonial or documentary evidence is desirable, It may send notice of such to the applicant and provide instructions as to how to proceed. Further, all applicants, of course, have a continuing duty to provide updated information to the Commission and the Bureau. It is now July 26, 2013, at 10 minutes past 3, and we will adjourn this judicatory hearing. Thank you for Mr. Manukian and Mr. Green for coming thousands of miles, and Mr. Carney for coming dozens of years.
Thank you, Chairman. Thank you, Commissioners.
All right.